The grandmother, accused of child endangering in Ohio's so-called House of Horrors case, has some big requests, and her attorney is telling us exactly what happened the day Christina Ciders and her family were arrested and taken to jail. I have all of the details. I'm
16 children, one home. A sheriff who says the conditions inside weren't fit for livestock. And at the center of it, a 66-year-old grandmother who says she's the one being punished before anyone's even proven a crime. This is the Ohio House of Horrors case, and right now it's not the prosecution making headlines, it's the defense. Christina Ciders is charged with child endangering, one count for every single grandchild who was living in that Vinton County home. Her husband, Gary Ciders' son, faces the same. So do their son, Gary Jr., and his wife, Elizabeth. 4 adults, 16 kids removed. All of them now in therapeutic foster care, the kind reserved for children dealing with trauma serious enough that ordinary foster placement isn't enough.
Christina Ciders is a grandmother and a mother. She's a wife, and she wants out of jail. Christina Ciders is accused of abusing 16 of her grandchildren by allowing them to live in conditions in a home in Vinton County, Ohio, that the sheriff said weren't fit for livestock. The children who were removed from the home, according to the prosecutor, suffered serious physical harm. The nature of the physical and emotional issues the children are dealing with remains under wraps, but we know all 16, including an 18-year-old, are in therapeutic foster care. Therapeutic foster care, it's different from traditional foster care. The caregivers are specially trained to help children who may have emotional or behavioral issues. The county had to find families to take in all 16 children. Let that sink in. Christina faces those child endangering charges, and so does her husband, Gary Ciders Sr., their son, Gary Jr., and his wife, Elizabeth Ciders.
All 4 defendants have pleaded not guilty. There's no grand jury indictment yet, and 3 of them are still sitting in a county jail on a $300,000 bond none of them
Elizabeth
can pay.
Ciders, they face the same charges for their 16 children. All 4 have pleaded not guilty to these charges. Now they are just waiting to see when the case will be presented to a grand jury and what happens when the grand jury returns indictments. And it's possible the grand jury doesn't indict members of the Ciders family. That's a possibility, but that seems very, very unlikely. And as 3 of the Ciders family members remain in custody in Southeast Ohio, 2 of them want to be released from jail. Elizabeth Ciders' attorney has asked that her bail be modified, saying she can't post any bail and wants to be reunited with her children. And now Christina Ciders, the grandmother of the children, is also asking Judge Rogers to modify the terms of her bail. Christina, Gary Jr., and Elizabeth are being held on a $300,000 bond. Not one of them can post that much cash, not even close. That's
where the story
clear.
turns. Christina Ciders' attorney has filed 2 motions that lay out, in her own words, exactly what she says happened the day law enforcement showed up, and why she believes her client shouldn't be behind bars right now. Here's the detail that changes how you think about the arrest. Officers didn't go to that house looking for Christina Ciders. They went to serve an unrelated misdemeanor warrant on someone else in the household. But by the end of the day, Christina Ciders had been interrogated for hours at the sheriff's office, without a lawyer present, and arrested outside her own home.
That's painfully clear in this case. And if they did post bail, they would have to wear a GPS monitoring bracelet. And now Christina Ciders' lawyer is asking that she be released from jail, and her attorney wants a mental health evaluation for her client. Attorney Kanda Roberts wrote, on June 30th, 2026, law enforcement arrived at defendant's home with the purpose of serving another member of defendant's household with an arrest warrant for unrelated misdemeanor charges. Nonetheless, defendant was detained and arrested outside her home. After providing a statement and cooperating with law enforcement during an interrogation at the Vinton County Sheriff's Office without counsel present, defendant was ultimately charged by complaint with 1 charge of endangering children, a second-degree felony for each of her 16 grandchildren who had been residing with their parents in defendant's rented home. Defendant has remained incarcerated since her arrest.
Her attorney also points out something the public still doesn't know: law enforcement executed a search warrant at that house, hunting for evidence in a case they still haven't disclosed. The documents behind that warrant are sealed, and now the sealing itself is being challenged all the way up at the Ohio Supreme Court.
Her arrest. I should point out, this was not just sheriff's deputies and agents with the state's Bureau of Criminal Investigation serving an arrest warrant on Gary Jr. for misdemeanor charges. Law enforcement has said they went to this home to execute a search warrant, searching for evidence of a crime they have yet to disclose. The manner in which those documents were sealed is being challenged at the Ohio Supreme Court. Bail is, of course, supposed to ensure that a person charged with a crime shows up for court. It's not supposed to be a punishment. Roberts cited case law, writing, if a court orders financial conditions of release, Those financial conditions shall be related to public safety, the defendant's risk of non-appearance in court, the seriousness of the offense, and the previous criminal record of the defendant. Roberts continued, the court must consider the defendant's ability to pay.
So there's the official story, child endangering, unsanitary conditions, 16 kids in crisis. And there's a second undisclosed investigation running underneath it that nobody's talking about yet. Now here's where the legal argument gets sharp. Bail under the law exists for one purpose, to make sure a defendant shows up to court. It is not supposed to function as punishment before trial. Christina Ciders' attorney is arguing that's exactly what's happening. That a bond neither she, her son, nor her daughter-in-law can possibly pay isn't bail. It's a cage dressed up as a legal formality. And she's backing that argument with something prosecutors can't easily wave away according to the defense. The actual evidence disclosed so far amounts to this. Christina Ciders was present in the home, and the home was in poor condition, that's it. No evidence yet, the filing claims tying her personally to abuse. No evidence yet showing she caused physical harm to any specific child. The charges require proving both for every one of 16 grandchildren. Is that the full picture? Almost certainly not. This is one filing from one side. But it's a reminder that charged and proven are two very different words, and right now, this case is still living in the gap between them.
Ability to pay. Setting a high bail in order to keep someone accused of a crime incarcerated pretrial is both statutorily and constitutionally unlawful. Christina Ciders' lawyer also questions the weight of the evidence against her. The state has charged defendant with endangering children, which would require evidence that on or about June 30th, 2026, defendant did abuse each of her 16 grandchildren and that she caused serious physical harm to every one of the children. To date, the defense has received scant evidence suggesting defendant committed any of the alleged offenses. The weight of the evidence against defendant is minimal. In fact, to date, there is no evidence that has been provided which would support the finding that defendant committed any acts of abuse, let alone that any of the children suffered serious physical harm because of abuse by defendant. To date, the state has presented evidence only that defendant resided and was present in the home on June 30th, 2026, and that the conditions of the home were unsanitary to the extent that the removal of the children from the custody of their parents was deemed necessary by authorities.
Then there's the second motion, and this one might be even more consequential. Christina Ciders' attorney is asking the court to evaluate whether her client is even competent to stand trial. Not guilty or innocent, competent. Can she understand the charges against her?
Necessary by authorities. Christina Ciders' attorney says she has no prior criminal record, and while she can't return to the home on Omer Street, she has a place to stay if she's granted bail. Roberts wrote, defendant has strong family support. In fact, in release, defendant will reside with close family members who are capable and available to assist in ensuring defendant's appearance at future court proceedings and defendant's compliance with any conditions of pretrial release imposed by this court. Defendant's financial resources are limited as demonstrated by her indigent status. As such, she has no resources or access to means which would make her a significant risk of flight to avoid prosecution. Defendant has resided in southeastern Ohio all her life. Defendant has no family or other connections outside of the area. Defendant requires medical treatment related to her mental condition and many documented medical diagnoses, all of which can be addressed while defendant
Can she assist
is not
in her own defense? Those are the two questions Ohio law requires a court to answer before a case can move forward at all.
while defendant is not incarcerated in jail. Roberts continued, writing, none of the statutory or constitutional factors relevant to this court's consideration of defendant's request that she be released on bail weigh in the state's favor. Rather, each and every factor weighs heavily in defendant's favor. Defendant poses no threat to the public. Defendant is not a flight risk. Defendant's lack of criminal history, age, medical concerns, family support, attorney-client relationship, and condition that she will be placed on GPS monitoring in release all demonstrate that she is not a flight risk and that she will appear in all future court appearances. Keep in mind, each defendant has waived his or her right to a preliminary hearing, which would have required prosecutors to present evidence to show there was probable cause. That
She's
each
not
of them
the only one. Gary Ciders' attorney has raised the same issue. That's 3 of the 4 defendants in this case now formally questioning whether their clients can even participate in their own trial.
That each of them had committed a crime. The case hasn't even gone to a grand jury that we know of. Now, Christina Ciders' lawyer, she's not just asking for her client to be released on bail. She also wants her competency to stand trial evaluated. Attorneys for Gary Jr. and Gary Sr. have also made that request. Roberts wrote, defendant, by and through counsel and pursuant to a revised code, hereby raises the issue of her competence to stand trial. Counsel has reason to believe that defendant is unable to fully comprehend the proceedings in this court and is unable to assist counsel in the preparation and defense of this case. Defendant moves this court to order that defendant undergo a competency evaluation to determine
Former
if
Franklin
defendant
County prosecutor Ron O'Brien didn't seem surprised by that pattern. He pointed to the sheer scope of the allegations: 18 children born over 15 years, 16 still living in that home, and said the nature of the case alone raises the question everyone's already asking: what was actually going on inside that house?
So let's dig into these motions filed by Christina Ciders' attorney. I want to bring in Ron O'Brien. He is the former Franklin County prosecutor. The elected prosecutor was for many years in Columbus, Ohio. So Ron, thank you so much for joining me. I appreciate it.
I'm glad to talk with you again about this very interesting case.
Yes, it's very interesting, and we have more questions than answers at this point. So, Ron, talk to me, if you would, about, let's start with the competency request. This is now the third defendant of the four in this case who is raising the issue of competency. Are you surprised by that?
No, not at all. I think just by the nature of the offense itself, what's publicly been disclosed, you have to even ask yourself, what are these people doing? What are they thinking? How did this happen? 16 children, or actually 18 children born over a period of 15 years, some of them twins, but wondering what's going on there. And so, as many people will ask themselves, is there something wrong with them? And so I think that itself causes you to think that maybe there should be a preliminary psychological exam of the defendants.
So we have Graham on now. Her attorney, Kanda Roberts, is with the Ohio Public Defender's Office. So they're going to do everything they can to help their client, of course,
Sure.
As any defense attorney would. What's the next step here? I mean, the judge, I'm assuming, Judge Rogers, is going to say, yeah, let's go, let's do it. Let's order the competency
O'Brien
evaluation.
predicts the judge will almost certainly order the competency evaluation, even though the motion itself offers thin justification. Why? Because judges tend to err toward caution when a defendant's mental state is in question. Better to evaluate and confirm competency than risk a conviction that gets overturned later, because it shouldn't have gone to trial at all.
Evaluated.
I think you're correct that the trial judge will order the competency exam. Sometimes the defense attorney offers more to the judge as a basis to order the competency exam, such as when I visited the offender in the jail, they couldn't tell me about the offense, or they talked about other things, or they couldn't remember things, kind of the questions that the psychologist is by statute required to look into. But in this case, it was a bare-boned motion that merely said, I have questions whether or not the defendant's competent. Therefore, I'd like to ask for an exam. Despite the lack of reasons being offered, I think the trial judge will order the competency exam, perhaps just based on the offense itself, the age of the offender, and the request by the defense attorney. Because they're obviously, she may have interviewed the defendant for hours in the jail and reached that conclusion herself, but she just doesn't.
And if she's found incompetent, that doesn't end the case. It pauses it. Competency can be restored through treatment, through time, and the prosecution still gets a shot at a second opinion if they disagree with the first finding.
Let's say, let's just do a hypothetical here, that the reviewer and the court find that she is incompetent to stand trial. That doesn't mean that competency can't be restored. We've seen that in a number of cases over the years where somebody is deemed incompetent, then they are sent to some type of institution and they work on them by whatever means that is, to get them to a level where they can assist in their own defense.
I think that's
O'Brien has seen it happen both ways, evaluators reversing themselves after a second competing exam. It's not an exact science. It's psychology meeting the law, and the two don't always agree.
And then they render the conclusion one way or another. If there would be a finding by the initial examiner that she's incompetent, the state has the opportunity to ask for a second exam. And at least if it would come out contrary to that, the court itself then can appoint a third examiner kind of as a tiebreaker, or can consider the two competing examinations. I recently had a case where the first representing the defendant, or no, in that case, I was representing the victim. Under Ohio law, the victim has a right to their own attorney. And after the first exam, they determined that he was incompetent to stand trial. I asked the prosecutor to seek a second opinion, which they did. And the second opinion reached that they were competent. And the report that that examiner provided caused the first psychologist to change their mind. And
Mm.
there was then a finding that they're competent. So, I used to like to call some of these kind of exams voodoo science, but they're professional opinions by qualified
Sure.
experts. Some of them have different kinds of leanings and biases. But in any event, the first exam is probably the most important because either side, if they agree with it and it's documented well, it can be accepted and be the basis for the finding of competency or incompetency.
As for bail, O'Brien puts the odds at close to a coin flip, not because the arguments are weak, but because of a complication nobody's mentioning. If Christina Ciders is released, evaluators typically need consistent access to her for the competency exam, access that's easiest to guarantee when she's still in
The
custody.
issue of bail. Right now, Christina, Gary Jr., and Elizabeth, they're all being held on a $300,000 bond. We know they can't post this. We get it. We know. So she wants her client released on bail. She said she has supportive family members who would make sure she gets to court appearances, etc. How likely is this to be granted a reduction in bail? Because we don't even have a grand jury indictment right now.
That's
We
correct.
don't know what the grand jury's going to do. So
There's no indictment, and actually, she's not. She's now going to be examined for competency, and generally, the psychologist would want the easy availability to the defendant, which is occurs when they're in custody. And so, I think that the chances of a reduction are probably.
A judge trying to avoid a legal challenge down the road might split the difference, cut the bond, but not enough for her to actually walk. And even if she could post it, where would she go? Not back to the house on Omar Street. Her husband is being evaluated for competency himself. Her grandchildren are in state custody. The family support her attorney describes in the filing is real, according to the motion, but it raises its own question. If that support existed, where was it before 16 children ended up living in conditions a sheriff compared to livestock quarters?
Victims. And in this case, where is she going to go if she was given a signature bond today? Well, the only place she has to go is back to the house where these children were held. I don't know what other family, when they talk about family support, I don't know whether family they have. That wasn't indicated. But besides her husband, who himself is being examined for competency, and the children, which are in the custody of adult or children protective services, what family would she go to? Where would she live? Those are, I think, important questions.
That question sits underneath everything else in this case, unresolved for now. Vinton County Children's Services has already signaled they're moving towards seeking permanent custody of the children, a separate proceeding entirely, decided by a juvenile court judge, built around one core question: are these children safer permanently removed from this family than returned to it?
The Vinton County Children's Services, they're going to be seeking permanent custody of these children. The county prosecutor told the county commissioners that just in the last couple of weeks. I mean, that was before this week. It was like 2 weeks ago. That early on, what does that tell you if they're seeking permanent custody that early on?
Well, they would have to have a hearing before the juvenile probate judge there in Vinton County. They would have to file an abuse, neglect, dependency kind of charge, which is a separate kind of administrative proceeding in front of the juvenile court judge to make that determination whether the children are at risk, that's the allegation, and whether the custody of the children should not be with these parents or grandparents who had such neglectful conduct over a period of time. So it tells you that they think they have a strong case, number one, and it also tells you that they're willing to go forward at some kind of hearing in juvenile court in the very near future to justify that claim.
Candid
Meanwhile, this
Robert.
isn't the first time truancy concerns follow this family. Records show they'd previously lived together in neighboring Gallia County, where truancy charges were filed and later dropped, not because the allegations went away, but because officials couldn't locate the family to
The
serve
fact
them.
that these people shared addresses in Gallia County. So they were living together at a house on Honeysuckle in Gallia County when the truancy action was filed. So these people have been living together for a really long time.
Right, and you would think also with regard to that issue that a grandparent would understand that it's in the child's interest and required by law that they attend school when they reach a certain age. And most of the children, or at least more than half of them, are over that mandatory minimum age. And as we talked about last week, they in fact had truancy charges filed on them that never went forward because they couldn't get service. So either they left that place and didn't leave a forwarding location in Gallia County, or the sheriff's office or children's services down there, or the truancy officer. Each school district by statute has the ability and does appoint what they call a truancy officer. And so all of them didn't follow up once they filed the charge.
Mm-hmm. Yeah.
No indictment yet, no trial date, no public disclosure of what that sealed search warrant was actually looking for. What we have is a family in custody, 16 children scattered into specialized care, and a defense attorney building a case, motion by motion, that her client is a scapegoat for conditions she didn't create and can't be proven to have caused. The next move belongs to prosecutors, and to a judge who now has to decide two separate high-stakes questions: is Christina Ciders capable of standing trial, and does the Constitution allow the state to keep her locked up while she waits to find out?
So as of now, all three defendants, Christina, Gary Jr., and Elizabeth, remain in jail on that $300,000 bond. Prosecutors have not responded to these motions filed by Elizabeth's attorney and Christina's attorney to modify their bail. So when they do, we'll let you know what they say.